It's April 2nd. Welcome to YesToHellWith.com. At the beginning of this good faith belief video series, I told you that I would have a surprise. Today I will share it. The U.S. Supreme Court said in United States versus Cheek that willfulness requires the intentional violation of a known legal duty. And if a man sincerely and honestly believed that the law did not impose that duty upon him, then that belief mattered. But here is the hard truth. A belief that is not documented may later be treated as though it never existed. If we look at the cases of Vernie, Kuglin, and Tommy Cryer, both acquitted of willful failure to file, we see that the jury had some kind of documentation for both of these people. The jury could see that these two had studied, questioned, and formed sincere good faith beliefs. Their beliefs were not merely in their minds. Their beliefs were on paper. And because they were documented, the jury could weigh them. Now contrast that with what happened to me. Long before I was arrested, I had spent years studying these very issues. I had written letters. I had read the books. I was a member of the Save a Patriot Fellowship. I was a member of the We the People Foundation. I had attended meetings. I had records of what I believed. But by the time the government came for me, my wife had become a government spy. My home was gone. My records were gone. My possessions were gone. I was raided at gunpoint in a public venue by a SWAT team of 15 agents with a fat CID IRS agent leading the way. I was immediately placed into jail and then isolation among the murderers. When I stood in court, I learned something devastating. The system doesn't care what you say that you believe. The system cares what you can prove you believe. My lawyers, when I used them, would not present my good faith defense. They said it was crazy. The court obstructed my efforts to even refer to the letters, questions, and documents that once existed. And without that evidence, the jury could not fully see what had once been there. That is why I say this to you. Do not make this mistake. If you are serious about protecting yourself, whether on taxes, property, licensing, regulation, or any other issue, then preserve your record. Duplicate it. Make 3 copies of it. Keep one in your home. Put one in the bank safe deposit box. Keep one with someone you trust. Store digital copies in more than one place. Preserve your letters. Preserve your notes, your statutes that you studied, the cases you relied upon. Preserve your questions, because one day memory will not be enough. Your word will not be sufficient. You will need a record. That is why I created the Liberty Dialogues, to teach you how to think. Authority, jurisdiction, status, standing, obligation, enforcement, under the overarching umbrella of presumption. And that is why the Statement of Understanding program exists. It transforms sincere belief into a documented, organized, preserved evidentiary record. This is the surprise, and that is that the program includes not only the Statement of Understanding itself, but a complete good faith belief letter series directed to congressmen, senators, and agencies. Those letters are designed to make your position clear, to show your questions, to show your effort, to prove that you did not hide, evade, or act recklessly. They preserve a written record that you sought answers directly from the very people responsible for the law. That is what makes this so powerful. The program does not merely teach you what to believe, it teaches you how to create the record of why you believed it. A record that may one day stand between you and the full force of presumption, and I might add, fraudulent presumption. The system depends on confusion, your confusion. The system depends on silence, your silence. The system depends on people who cannot explain why they believe what they believe. Do not give it silence. Give it a record. Visit statementofunderstanding.com. Secure peace of mind today. And as always, may truth reign supreme.